they can do that anyway. That's our read from the opinion. So it's not really. We're not claiming a huge victory, but we think that the court absolutely left Senate Bill 1 intact and left the intent of the legislature intact as well.
They did do that, but the court said that because there is a narrower definition now of an accidental injury, that some people who might have previously been covered under workers' comp may not be, and those people could now go to court under common law. And what Mandel is saying is that that could include, say, carpal tunnel cases. No longer in workers' comp, just go to court and sue the employer.
We'll have to see, but for that injured worker, you got to ask the question is, do you want more immediate payment of benefits, awarding of benefits if appropriate, or do you want to risk going to court and a much lengthier process of the whole claim process and possible added expense, and then you have to judge whether you're going to get what you would have gotten out of workers' comp through the court system. I mean, it's a crapshoot, and it's a risk for that injured worker. And so, all due respect, I don't doubt that Mr. Mandel's going to claim victory. Probably a lot of billable hours for this, but I don't think it's that way. We're not hearing that way from defense attorneys.
The bottom line, I guess, is do you have any concern that businesses may now have to defend more lawsuits?
We are right now not worried about that. I think there might be an exception to that, but in general, the reforms of Senate Bill 1 are intact. And I'll remind you also that out of the states that surround Missouri, the 8 contiguous states, the recommended rate decrease in Missouri was the highest in the Midwest, highest out of all those states. Senate Bill 1 is working, and the work comp system is still intact for that worker who gets injured on the job, and the employer gets him the benefits and the health care he needs so he can get back to work.